Um, Good day to everybody. Greetings to the candidate. Advisory group of experts will conduct an interview with a candidate for the position of a judge of the Constitutional Court of Ukraine, Mr. Mykola Mikhailovich Voinarivskyi, who serves as a judge and active chief judge, Mykolaiv Realm Court of Mykolaiv Oblast, and has been allowed to participate in the competitive selection by the Parliament of Ukraine. AGE Secretary will moderate this interview, so I'm passing the floor to Mr. Yaroslav Romaniuk.
Дякую.
Please, yours.
Дякую, пан.
Thank you, Mr. Chairman. Greetings to dear colleagues, to the public, and to the candidate. All 6 AGE members are present here. So the AGE chairman, Ales Zalar, who participates through Zoom. Physically, we have here Miss Hanna Sukhotska, Miss Maureen O'Connor, Miss Natalia Kuznetsova, Miss Oksana Vasilchenko. AGE deputy members are also in attendance, namely Thomas Griffith, Richard Barrett, Marek Zubik, Vasil Shakun, Volodymyr Kuzmenko, and myself, AGE Secretary Yaroslav Romaniuk. Mykola Mykolayevich, we will have enough time to collect information and data about you, and we're grateful for your communication and for your active answers to the posed question. We have collected a lot of positive information, but together with it, there are some questions that we would like to clarify and give you the possibility to clarify any doubts regarding your high moral qualities that are requested for the position of a judge of the Constitutional Court of Ukraine. We have to warn you that we won't take into consideration information documents and other materials that you haven't presented to us earlier but provide it today, or if there is information that you decided to present only today during the interview. However, the advisory group may make an exception if it determines that such an exception is justified. I also would like to inform you that the interview is being recorded and streamed live on the AGE Resources as well as the Constitutional Court of Ukraine website. Therefore, I call upon the AGE members and the candidate to limit the use of sensitive data and limited access information on live air. If there is necessity to discuss such sensitive data, we will terminate the streaming for the period of discussion. I would like also to draw your attention to the fact that the duration of the interview is approximately 1 hour. I would like to ask you to be laconic and concise, and the time limit for the response to a question is 3 minutes. If you don't understand English sufficiently, please take the headset, because some AG members are English-speaking, so we have simultaneous translation. And there is opportunity for you to use the headset to hear the Ukrainian translation. Also, at the end of the interview, the candidate, so you, may make a short closing statement up to 5 minutes. If it is clear for you, then we can start. And I would ask the rapporteurs on the candidate Voinarivskyi, Ms. Vasilchenko and Ms. Sukhotska, to start asking the question. Thank you so much. So, Mykola Mykolayevich, I think that you know which questions should be clarified during the interview, and let's start from the event in 2023. I mean the resolution of the judge of Centralny District Court of the city of Mykolaiv as of January 16, 2023, in case of closed the proceedings in the case of committing an administrative offense for you, driving while intoxicated or refusal to undergo medical examination due to the absence of an administrative offense in your cases. I would like to say that we do not doubt the legality of the resolution. Our goal is to investigate your behavior during the formulation of the protocol, during the explanation, during the communication with the law enforcement bodies, because we evaluate you as person that should have high moral quality. So when we found out this information, it can be seen from the contents of this resolution passed by the judge that in the process of compiling the protocol of 27th of September 2022 on Committee on Administrative Offense, you provided that you are not employed, and you said that your following address, the city Mykolaiv, 25th Naberezhny Street, apartment 24. In your response to the written inquiry made by the advisory group of experts, you informed us that the information contained in this protocol regarding your personal data was not true. So that's why. Tell us, please, why did you not note it in the compiled protocol that the protocol compiled by the police contained wrong personal data? And also, why was the question of undue protocol drawing up not raised in either the objections to the protocol submitted by your defense lawyer, Voinarivskyi, or during the process? So why this false information was there? Good morning, dear chairman, dear members and the deputies of the AGE. This is a big honor for me to participate in this interview. As for the first question, I would like to drive your attention to the fact that all these indicated data, they are wrong about my employment and my address, because due to the page number 5 about the added proofs to the protocol, it is written that there was a report of the police officer. It was written in the statement number 3. So the indicated data is undue because due to the page number 5 report of the police officer, it is indicated that I informed about my position as a judge of Mykolaiv District Court. It is written in the preceding case. Mykola Mykolaievich, you haven't provided the video as the site of the proceeding. It is clear that the AG addressed the subjects and the sites of the proceeding, and we have the video from the body cam of the police officer with the fixation of all the circumstances of communication with you during the event that we are discussing today. If you don't mind, we can, only for the AG members, show this video recording because we would like to ask you questions about the events. I do not mind, but I would like to drive attention of the members of the AGE to the fact that as we are legal specialists, as for authenticity and origin of this video recording, if we pay attention to the protocol and added documents, there is no disk and other carrier of the video with the circumstances of the protocol formulation. And I would like to say that this video erased I don't know when, why, and it was added to the protocol from beyond the framework of the legal statement, and it cannot serve as an evidence during the trial, and it cannot be evaluated as an evidence for the AG group, because this video recording cannot be identified. It doesn't have any data, any number. It is not enclosed to any procedural document, and as we know, even if there is decision on homicide taken by the Supreme Court of Ukraine, there was an acquittal because there were no evidence. So if the AG says that you want to see this video, I am not against, but I would like to say that it is not an evidence. I'm sorry, but we have timing, and I completely support your position. Just I would like to say that we are not during the trial. We are not talking about the determination whether there was offense or crime or something like this. We are just talking about your qualities as a candidate for the position of the Constitutional Court of Ukraine. I'm not against your position, but I just drive. So, can you say, are you there in this video? I would like to say that when finally I addressed 3 times to obtain these videos, and at first they couldn't find the case, then they said that they sent to you the materials, but then when I said that I would claim them, they presented me this video, and studying this video, I would like to say that this video doesn't have chronology of the events. It is cut. There is no consequence. And there is no continuity in this video. So to determine the circumstances that are there, so even if we take it abstractly, and if we say that this is an adequate, appropriate video, okay, Mykola Mykolaievich, you know about this video. Can you say, are you there in this video? I cannot say only from one point of view that I am there, because I don't know what events are mentioned there, and I had an impression that it was just an audit video because of my principal position due to some certain actions made by police. And the next day after the event, it was written that there were no evidence and no witnesses, but in the protocol it was written that I rejected everything. I addressed the police officer head. Mr. Mykola Mykolaievich, you said about witnesses, so please, it was the Article 266 of the Code of Ukraine on procedural offenses, and if we talk about the body cam, the witnesses are not mandatory to be involved. So I had just one question that we are talking about 10 minutes. Tell us, please, do you mind to ask you questions about this video? And now you can explain about the questions that we can answer. Again, talking about my position about this video, I do not know this video is about which events. It was obtained illegally and outside of the proceedings, so it cannot be used by a court or by the AG taking a decision about myself. Okay, it is clear. Tell us, please, in the protocol, when you said you are a lawyer with more than 20 years of experience behind, of which for 13 years you were a professional judge whose direct powers include considerations of cases of administrative offenses, actually you refused to sign a protocol on the administrative offense on the grounds that the police officers did not provide you with the right to a lawyer. Clarify, please, whether, according to the current CUAO, the absence of a lawyer is an obstacle of drawing up a report on the administrative offense. How can you explain your behavior in light of the provisions of the Code of Judicial Ethics? As for this protocol and its formulation, I would like to draw attention of the AGE members that due to the incriminated to me suspicion, no, we are talking about your qualities. We are not talking about offense. So it is written that I rejected to pass the medical examination. I ask you about a lawyer, Mykola Mykolavich. I am asking you about a lawyer, and you are talking about medical examination. Well, I should be aware what is there in the protocol, and I can take. It is not an obstacle for drawing up a protocol. Mr. Mykola Mykolavich, please answer the questions that we ask you. We are not talking about whether there was or there was not administrative offense. Mykola Mykolavich, we do not check whether it happened or not. We are talking about your correspondence to the high moral values for a position of a judge of the Constitutional Court of Ukraine. Honesty, openness, etc. So we are not proving that you are to be blamed or not to be blamed in this administrative offense. It is clear? So, okay. Well, we do not want to study the composition of the offense, so here we understand your position, and now I pass the floor to Ms. Hanna.
We have some exactly doubts concerning the general issue conflict of interest. Are you familiar with the Bangalore Principles of Judicial Conduct, which states that the judge shall recuse himself or herself from a case if it's not possible for him or her to render an objective decision in the case, or if an outside observer might doubt of judge's impartiality? In your response to the written inquiry made by the advisory group of experts, you informed that the final beneficiary of authority, Voinarivskyi Mykola, was your defense counsel in the above case on the administrative offenses. You also informed us that your relatives do not have any relations with this person. At the same time, according to the information the advisory group of experts has, till 9 September 2009, you had been the head of the law firm authority. Then, since 23 September 2010, your mother, Voinarivskyi Mykola, became the head of the company. From 23 September 2010, and up till present, Voinarivskyi Mykola has been the head of the law firm authority. According to the Unified Register of Court decision, you, a judge, considered case, a number that I would not read, based on the claim filed by Morozova against Aksionov, Farm ABH, Aksionova, third parties. The State Architectural Construction Inspectorate in Mykolaiv Oblast, Mykolaiv, the Village Council of Mykolaiv Region, etc. The case was resolved in favor of the respondent. And now is a question to you, and we expect a clear answer. Taking into account the fact that the lawyer Voinarivskyi is your trustee, since you use his service in your personal case, this person is currently the head of a law firm that belonged to you and later to your mother, why, when considering the case we are discussing, where lawyer Voinarivskyi acted as a representative of the respondent and in whose favor the decision was passed, you did not declare self-recusal.
Дякую за запитання.
Thank you for your question. As for conditions on self-recusal, at that time when I was considering the case you just read about, I had no relationship with Mr. Voinarivskyi or legal firm Authority K. As of the moment that I was appointed for the position of the judge, I didn't have any relationship with him. Moreover, I explained to the parties the right and the possible of the self-recusal, and I gave the grounds, but the fact that in 2023 for a few days this defendant was involved is not the legal ground when I considered this case for self-recusal. As for my activity before I was appointed for the position of the judge, I indeed exercised the lawyer activity, and I was the head of the above-mentioned enterprise, but 15 years have already passed from that period of time, and currently, since I knew this man as a professional and engaged him for the defense of my rights, so there was no relationship with a specified person that would give me the right for the self-recusal. And there could have been this question, as we have been working together with this colleague for a very long time. So we have no full composition of the court for a very long time, so not seeing the grounds for self-recusal. Moreover, if I'm not mistaken, this decision was not challenged by any of the parties. It became valid, it came into force, and that's why the right of the self-recusal was not applied. But I do not think that there was the legal grounds for self-recusal in the specified case. Our city is small, the legal community. Okay, we understand. You don't see the grounds. No, at that moment of time, there wasn't any.
Important question, because you are asking for the position, very high position of the judge in Constitutional Court when the high moral standards are needed. Yes, so it is also should be taken into account when you took the decision before. Thanks. And now, Ms. Oksana.
Дякую. Я ще раз хочу звернути.
Thank you. So we are no qualification council, High Council of Justice. We do not investigate the violation of the procedures. We are just trying to find out whether your high moral qualities are in line with the one that the judge of the Constitutional Court is to have. So, given the rule of law, how can you explain the fact that when you were in the composition of the court, you just considered the case, the administrative materials about people bringing person to justice under Article 130 of the Code of Administrative Offenses, as a result of which such persons avoided liability. You said that the reason for this was always to ensure the rights of persons held liable to familiarize themselves with the case file and to be informed of the time and place of the trial. So from the point of view of the principle of the rule of law, its composition is irreversibility of the punishment. How can you explain these facts? Thank you for the question. As for the statistics, I should disagree with you. For the period of my work as a judge, more than 17,000 of decisions were made. We have the common jurisdiction. We consider both criminal, civil, and administrative cases, and also the administrative cases. And at that time, the legislator has set the restriction to 3 months period to hold people liable. This has been amended, and now the court can
hold people liable during 1 year. So, as for the cases that were listed in the inquiry, I can inform the following. No case was out of attention of the court. All of these cases, they were to be considered by the court during 3 months, and the case was appointed for the consideration, but the law limits the court's right for the certain categories of the cases if there is no person. And there are certain confirmations in the materials of the case that these persons, they were enrolled and the court cannot be sending messages, but we are, or sending or calling people, but we do this in order to invite people to the court hearing. Apart from that, as a judge, I mean my colleagues, I'm not doubting that, I'm not saying you do not act in line with the law. I have a question because the judge of the Constitutional Court envisages another perception of the legal processes. I asked you about the principle of the rule of law. And this situation, how do you see, what is the resolution of the situation? Well, thank God the legislator has solved this. And currently there are no such problems, as we have not 3 months as it was at that period of time, but we have 1 year. Moreover, we are using the email and we contact the local authorities. So the question is the principle of irreversibility of the punishment. How do you assess this fact that the persons avoided liability? The persons who created serious threats for other participants of the road because they were driving, being intoxicated. Dear members, I would like to inform you. I think it's considered to differentiate the liability in this violation from the punishment. The law limited to hold them liable in 3 months, but all of these persons, they were held liable. I did set the composition of the offense, and they were seen as guilty, but the sanction wasn't applied because the term was not valid anymore. So, guided by the rule of law, these people were invited to the court session for multiple times, because apart from the mentioned rules, another principle is important, that is the right for protection, the right to communicate to the court on the conditions that took place. Okay, we understand you. So these persons were held liable. Yes. So, and the punishment was not used because the period was over. No aim to. Okay, we understand.
Question to you because your answer was not very clear. And now is the question concerning the land plot purchase sale agreement. And based on the land purchase agreement dates March 17, 2017, your mother, Voinarivskyi Mykola Petrivna, acquired a land plot area 694 square meter, cadastral number, you know it better, in the village of Koblevo. And in the purchase sale agreement, the cost of the land plot is determined by the parties as 28,303 Ukrainian hryvnias, which back then was equivalent to some $1,500. The land plot in question is located in a residential area, a recreational area, close to the sea, and apparently had a high commercial value in 2017. According to the website with advertisement for the sale of movable property, the cost of land plots of the same area and the specific settlement is about 140,000 million, yes, 1,000 million, how it is, Ukrainian hryvnia. Explanation, and we need your explanation, how it was possible that the price was so under evaluation, the price you paid for this land, your mother land. Please give us more information about it.
Дякую за запитання.
Thank you for your question. First thing I want to draw your attention to, dear members of the advisory group of experts. As for, I'm aware of the conditions at which my mother has bought this land plot. Please pay attention that mother is not member of my family, but I will inform you since you have this question. So, as for a statement that this land plot is located in a recreational area, well, it does not refer to the recreational area. It's not recreational area because it is the area where we have swamps. Second thing, on the cost or price for this land plot, it was defined in accordance with the cadastral register, and it is evaluated by our state. And analyzing the specified agreement, it was also mentioned that this evaluation was made by the expert organization that bear the criminal liability if they give false evaluation. Moreover, the price in the agreement is the free right of the parties to define the size of it, and for the time when it was acquired, as far as I know, this could only be valuable if some work was to be done to dry out these land plots. So you confirm that this is not underestimated. Yes, at that moment, it was in line with the evaluation held by the state and also the expert organization and the market that was relevant today. I can't, of course, state, but I think many kilometers away from the sea, by the way, and it's not the recreational area. Because when I got the inquiry, I was clarifying all the information about this agreement. Okay, we understand your reply.
Right, but I don't know if the reply totally convinced us. So, now it's Oksana.
Дякую. Микола Миколаївич, давайте...
Thank you, Mykola Mykolaievich. Let's remember those events that were subject to the analysis and want to hear your position. And in 2010, you sold the apartment to Yusufa, a citizen. And the price that was specified in purchase sale agreement was 21,000 hryvnias, which was about 2,500 USD. After you sold it in 2011, you register at. So in 2010, you registered at the address of the place of residence of your mother, and then you register in Mykolaiv Regional Registration Center for Homeless Citizens. And there you were registered in the period from 2011 to 2014. And from the moment that you registered there, you in 2011 got registered in a housing queue as a person in need of a place of residence, of the apartment. At the same time, in 2020, you specified that you went back to the apartment earlier sold to Yusufa, not apartment, but room. Okay, and to the apartment sold to Yusufa on the terms presupposing that you pay the debt for utilities. So this round of events, what do you think? Can it serve as the ground that you artificially worsened your living conditions in order to obtain the apartment? Thank you for your question. I would like to draw your attention to first, I understand this question, and during my work as the judge for over 13 years, this year it will be a 14th anniversary, no property for privatization or for the right of use from the state or the local authorities or members of didn't get or didn't gain, neither me or my members of the family, if you speak about the artificial conditions in order to worsen, yes, my living conditions, as you said. Selling this apartment was due to family conditions, and if there's a need, we can stop streaming and I can explain it to you why we needed money and why the cost was like this and why we sold it very urgently. As for me returning to this apartment in 8 or 9 years, well, the owner of the apartment informed me about having the need to rent it or sell it, and I at that moment didn't have my own place, and I rented this apartment, but only one room of it. So the owner lived in one room and I lived in another room. And I paid the debt for the apartment, I mean the utility bills and other services, and I showed it in the declaration, so I did not restrict information on these conditions. And I don't think it's weird, as you say, all this round of events that are related to these circumstances. Life was like that, and I have informed the authorized body of it. Moreover, holding a very important position, we undergo different checks, including of tax authority and law enforcement authority, and no remarks when conducting the inspection or checks were in place. And the authorized body did not provide me any questions concerning this. And this did happen in my life. So artificial deterioration of living conditions in order to obtain housing at the expense of the state is not true and did not take place. And I didn't send any inquiries or requests to the local authorities asking for any habitation. I did not apply for it. Ever since I was appointed as the judge, I have never submitted it. Yes, but you are in a housing queue. Yes. All of my colleagues got registered in a housing queue. Moreover, the law set the obligation to do so, but it was not fulfilled by the state. No service accommodation me or my family obtained. Okay, let's go back to our competition. Of course, we have studied all of your documents, and we were interested in the statement in your motivational letter where you indicated that you were motivated to become judge of Constitutional Court of Ukraine, since your main goal is an unreserved desire to change the activities of the Constitutional Court of Ukraine for the better.
In the same time, you are taking also part in the competition for the position of a judge of an appellate court. So explain which of these two motivation letters you were sincere. Well, as for appellate court, I participated in this contest since 2019. The competition duration was from the 2019 till 2023. Then it was cancelled by the qualification commission, and a new competition was announced. Yes, I submitted documents for the competition for a position of a judge of appellate court, and I think this is the right of the candidate to submit his or her candidacy in different organizations. About my sincere wish, it is because I worked as a lawyer, as a judge, as a professor, and all these experiences were different. So the knowledge I possess, I believe, give me a possibility to submit my candidacy both to the appellate court and to the Constitutional Court of Ukraine. About my unbearable decision, I think this is about the processes that happen now in Ukraine, that will happen after our victory, and I think that I can be useful in all these processes. And if you permit me to be admitted to this competition, I will be able to apply my knowledge. I understand that there is a lot of reforms to implement and to form in future, and it will depend on the Constitutional Court of Ukraine, on its composition and its decisions. If we look into historic context, we see that decisions then lead to other actions and activities. Yes, I support your motivation. I would like to say that your experience, what do you think you can improve and enhance in the Constitutional Court of Ukraine, and which reforms you think that are related to the Constitutional Court can be? Okay, I would like to be concrete about my position and my duties now. I think that judicial system needs to be reformed and constitutionally reformed also, because currently we have the Supreme Court, that is a unique one, but we have separately appellate administrative court, appellate commercial court, we have commercial regional court, administrative district court, etc., and separate jurisdiction courts. I think that there must be just unique courts, so a citizen being entitled to the access to the judicial power has the right to come to the court, to one court, and to obtain all the range of the judicial defense on different issues: criminal, civil, administrative, etc. So I think there must be also one link for appellate instance with different aspects in criminal, penal, administrative, commercial law. So, and in each sector also to have specialists of different spheres like criminal law, administrative law, commercial law, etc. I think that it will provide and enlarge and amplify the access for the justice, and it will defend the rights of civil people. So you think these are the powers of the Constitutional Court? No. We know that these are not powers of the Constitutional Court, but these are the questions and issues that earlier or later will arise in scientists, in legislators, and this issue should be considered also in the Constitutional Court. Okay, please.
To follow your question, to go the line, because you said that exactly you would like to, as I understood, to reform Constitutional Court to make it working better. But if you'd like to make such a job,
жодним чином.
yes, as a
No, I wouldn't.
judge of the Constitutional Court, you also, the judge of the Constitutional Court, also have to have certain conditions, yes, to be a judge. And we can note, as a group of advisory group of experts, your, how to say, systematic missing of deadlines for providing responses. And we found in your files that, referring to different technical issues, you missed the deadlines for submitting your answer to the inquiries made by advisory group of experts. You also did not meet the deadlines for submission of a full package of documents to the body which is dominating for you, the Verkhovna Rada of Ukraine. Do you not consider that these circumstances, taken together, raise reasonable doubts about the suitability of your candidacy with regard to the component of integrity, such as conscientiousness? So it is one of the important points, because now we are discussing not on the specific role of the Constitutional Court, but about the integrity of the candidate which is asking for the position of the judge. How is your explanation of this?
Дякую за запитання.
Thank you for your question. I would like to drive your attention to the fact that submission of the documents, it was considered during the committee of the Verkhovna Rada of Ukraine, and the delay was due to the examination on fluency in Ukrainian. So this examination has been passed, but there was no certificate and no excerpt from the register in time. That's why at first I sent the first package of the documents timely. Then I added this corresponding certificate about the fluency and the adequate level of Ukrainian language and excerpt from the register. As for the inquiries from the AGE, only one I violated the terms and deadlines, and it didn't depend on me, because I don't know why I cannot inform you about it, but talking with the representatives of the AGE, we found out that the email didn't obtain this inquiry, and after the phone conversation in the same day, I answered the questions and sent the written answer. So when I had possibility to provide you the answer, I provided them to the fullest extent and respecting the deadline.
Just interrupt here. Are you saying that the mail service is to blame for your not
Чомусь не спрацювали.
Yes, the mail service didn't work out, and there is also confirmation from the AGE members. So they had...
correct?
Так що воно не дійшло до...
Yes, they sent it, but the letter doesn't arrive to my email. That's why then I created another email address, and I informed the AGE, and the representatives of AGE sent the other inquiries to both emails. And also I paid my attention to the fact that invitation for today's interview I didn't obtain, and after my contacting the AG office after the 9 p.m. I obtained the invitation for today's interview, because it was sent to the previous email that I informed you when I presented my application for the first time. That's why I am open, and for a long time I work and I address all the inquiry that I have to my email.
У мене до вас є два запитання.
Mr. Mykola Mykolaievich, I have two questions. The first one, in response to your previous question, you say that you have quite a lot experience for this position. Tell us, please, have you researched maybe constitutional law, or have you published any articles in profile editions, or maybe you participated in some conferences and roundtables where the constitutional law were discussed? Thank you for your question. I would like to inform about the following. All the time I really express my interest about the constitutional reform, and I have already expressed my attitude towards the justice and implementation of law in Ukraine. It regards also constitutional reform. Moreover, I would like to state that now I'm preparing for the doctorate dissertation defense and it was dedicated to the guarantees under the commercial and administrative sanctions. It was my topic in administrative law, but unfortunately indicated topic was evaluated as not plausible on the in the Department of the Constitutional Law, and I continued my work in the commercial law on these topics. But personally, I am really interested, and all scientific events by the National School of Judges. I am the trainer of this school, and I am involved actively also in issues about the constitutional law. And in future, I plan, if you give me the possibility to be assumed at this position, I am planning to work in scientific regards about the constitutional law, because it will be my activity related to my practical. So there is also the contest on the quote of the Congress of Judges and on Verkhovna Rada. So you have been working as a staff judge for more than 13 years. Why you were nominated by the Verkhovna Rada of Ukraine, that is political body, and not from the Congress of Judges? Because when we talk about the parliament, the Verkhovna Rada, they are guided more by political aspects. So why you want to be appointed by the political body with political aspect for the position of the judge of the Constitutional Court of Ukraine, taking into consideration that you should be politically neutral for this position? Thank you for this question. I would like to inform that when I learned about the competition for the position of a judge for the Constitutional Court from the Congress of Judges, and I addressed the head of the Congress of Judges and about the possibility to be candidated. I was informed about the fact that the number of candidates already has been formed, and the list has already been formed. And as far as I learned, general requirement is experience and age of the candidate, guided by the Council of Judges and Congress of Judges. I think, and my position is, that age is relevant, but I think that younger people should be admitted also, and the desire and will is also very good sign. As for my political neutrality, I'm not politically affiliated with any party. There were 3 vacancies proclaimed by Parliament. I learned about it. I provided a set of documents. I passed the examination on possession of Ukrainian language, and I'm here now. Are there any other questions from the advisory group? Then we are ready to wrap up the interview with you, Mykola Mykolavich, but as it was stated, you are entitled to proclaim your closing remark. Dear advisory group of experts, members, deputies, the defenders, sorry, not defenders, deputies, I'm sorry, I'm a bit worried and excited. I would like to address you and say that it is a big honor for me to take part into such interview, and I express you my gratitude for admitting me to such an interview. I think that I am entitled to submit my candidacy for the position of the judge of the Constitutional Court of Ukraine and to pass this interview. As for my activity, since 2010, on the position of a judge, there were no satisfied recusals in my regard. So I think that the sides, they trusted me to take decision. During my activity, I took more than 17,000 decisions. We have general court, general jurisdictions, and we consider different types of cases. And in the first day of the war of Ukraine, when it started, I took arms in my hands, and the court that I had it didn't stop its activity, no one day. And in our court building, other colleagues worked there also, because it is, it's not in the center of Mykolaiv, it is near, it is on the outskirts of Mykolaiv. And up to date, no one day I was on a leave, and I have never left Ukraine. I have never been abroad. And also I changed my residing place because I wanted to live near court, that to have possibility to go on foot to work. I studied a lot. I got involved into different educational activities. I have PhD in law. Before becoming a head, I was an associate professor, and I am guided by the rule of law, by the supremacy of law, and I think that young people should take part in the implementation of the constitutional reform of the state authorities, and I think that I will prove plausibility of my appointment to this position. I would like to serve to the Constitution of Ukraine, to people of Ukraine, and to all integration processes that take part to join European Union, European society, and to follow all the international laws. Thank you for your attention. Thank you, Mykola Mykolaievich, for your answers. So the interview with the candidate Mykola Mykolaievich Voinarivskyi is closed.